Welcome to Constitutional Chisme,
a law baddie's guide to the legal basics. I'm your host, Stephanie.
And I'm your co-host, Harleigh.
Every week, we will drop an episode that you'll likely cover your first year in law school or some other bar course in your law school journey. Make sure to pay close attention to our podcast because we will drop Easter eggs of what case we plan to drop next week. See if you can guess which one. This is a bonus episode.
It is a bonus episode because we wanted to touch on the case of Obergefell v. Hodges, which is having its 11th anniversary on the day you should be listening to this. It should be June 26th, 2026, which makes 11 years since this decision was handed down. So it seemed only apt that we should drop a bonus episode about this particular case because you are probably going to cover it in con law. It is a very, very important case, especially when you're considering, when you start talking about things like the due process clause and the equal protection clause, you'll more than likely cover this case. So happy 11 years to Obergefell.
Cue confetti.
Cue confetti. Yay! That's what I'm picturing in my head.
I'll just put your part screaming yay.
Yay! Perfect. Everyone unsubscribes immediately. Okay. So this is going to look a little bit different than our usual episodes because I kind of wanted to go very in depth with this one. And after I get through how it got to the Supreme Court, what it held, why it's important, all of those good things, for the first time, probably not the last time, but for the first time, we're actually going to discuss the dissents in this case. And one of the reasons that I want to touch on the dissents is because the things that were brought up by the dissenting justices are part of the reason that modern critics of things like the Dobbs decision have pointed back to the dissents in Obergefell to say, well, if we follow the reasoning in Dobbs, Obergefell is also in danger of being overturned. So we'll get into all of that as well.
Okay, so this episode is sponsored by Belmonte, a skincare and lifestyle brand centered around the reminder to stay still, grounded, and present. We also want to thank Kaplan Bar Prep for partnering with us. Because of them, we've been able to help out at least 5 people receive free bar prep. So if you or anyone you know is going to use Kaplan for bar prep, be sure to use our code PASSWITHPONZ, and you'll save an additional $100 off your course. So whatever sale they have going on, this will stack. And we also have another discount code because we love to save you money for UWorld. So if you are needing the MBE supplement, which is a multiple choice section from UWorld, use code Ponzaneli10 to receive 10% off. And make sure you check out our link tree in the show notes where you can find where to follow us on TikTok, on Instagram, our Amazon storefront, where you can find out what we suggest for future law students and people studying for the bar. And we are still waiting for you guys to join our Patreon community. And we'd love to see you there. Okay, what is the case?
So today we are talking about the case of Obergefell v. Hodges, which was a decision that was handed down in 2015 and ruled that the fundamental right to marry is guaranteed to same-sex couples by both the Due Process Clause and the Equal Protection Clause of the 14th Amendment. So we're going to back up just a little bit to like 2012 because Obergefell was really a culmination of a lot of different cases that were pending throughout the United States. So for a little bit of context, prior to this ruling, there were about 36 states that had made same-sex marriage legal by statute or some voter initiative. So there were 36 states. The District of Columbia.
Was Arkansas one of them?
You know it was not.
Okay, perfect.
So between January of 2012 and February of 2014, plaintiffs in Michigan, Ohio, Kentucky, and Tennessee filed district court cases that all eventually culminated into what we got in Obergefell. So We're going to look at those cases.
So the cases we're about to talk about are from those states.
Yes, are all from states that did not have protections for same-sex marriage on some level.
Same-sex marriage, can you explain what that is?
Yes. So in states outside of, like I said, the 36 that allowed it, anyone who was trying to get married to someone of the same sex as they were, so let's say two men wanted to get married or two women wanted to get married, that was not considered a legal marriage under the framework because marriage was considered to be between a man and a woman. And the
Mhm.
states could choose to recognize other forms of marriage, but states outside of those states did not have to recognize those marriages. So if you got
Mhm.
married in a state where same-sex marriage was legal, they didn't have to recognize it in a different state. And you might not be afforded the same protections. So essentially, it wasn't just a ban on any people who were of the same sex getting married.
Okay, and there's a lot more to marriage than just, like, having a wedding, right? There's a lot of benefits of being married to someone. So, I guess what I'm trying to kind of, like, talk about too is, like, the medical portion of it. Are you gonna get into that in a little bit?
Yes,
Am I going too
some
fast?
of
Okay.
these cases are actually talking about not just the right to marriage itself, but some of the things that get protected when you enter into a legal marriage.
Okay, perfect. Okay. Then let's
So,
let's hop in. Sorry.
no, you're so fine. We're going to start with the case from Michigan.
Okay.
So, Michigan was DeBoer versus Snyder. And this was a case involving two women and their three children. So, April DeBoer and Jane Rouse held a commitment ceremony in February of 2007. So they had what was essentially a ceremonial marriage, but it was not a legally binding marriage.
Mhm.
So it's not
Because the
recognized
state
by
wouldn't
the
allow
state of
it.
Michigan. Exactly.
Okay.
So they were also foster parents.
Hmm.
And Rouse actually adopted a boy in 2009 and then a girl in 2010, followed by another son in 2011. So over the course of 3 years, they adopted three children. Now,
Mhm.
legally, only Rouse was the parent of these children. She was the only one who had legally adopted these kids.
Mhm.
So, Michigan law, this is where we kind of get into the protections that are afforded to those who can have a legal marriage. Michigan law only allowed adoption by either single people or married couples.
Mhm.
So, they filed a lawsuit in Michigan saying, hey, I'm also the legal mother. DeBoer was basically like, I am also the mother of these children, but I
Yeah.
cannot be legally recognized as their mother
Mhm.
because me and my partner cannot be legally married.
Mhm.
Originally, DeBoer brought the lawsuit alleging that the adoption law itself was unconstitutional, basically trying
Okay.
to argue that they should be able to adopt the child regardless of their marital status.
Yeah.
However, Judge Friedman expressed reservations about this and said, I'm not sure if that's the proper cause of action. So he actually suggests that they change their complaint instead to focus on the state's ban on same sex marriage.
Oh,
He
okay.
was like, dive a little bit deeper into this issue. And that's exactly what they did. So they ended up challenging Michigan's ban on same sex marriage instead and said that it prevented them through that from being able to both be listed as parents to their adopted children.
So who do you sue when you're doing that? Like, who is Snyder?
So Snyder was the then sitting governor of Michigan. So his full name was Richard Snyder, and he
Mhm.
was the governor of Michigan. And again, he was sued in his official capacity, which basically just means that you're basically a stand-in for the fact that the state itself is being sued. And you're going to see that kind of repeat with the other cases as well. On March 21st of 2012, Judge Freeman ruled in favor of the plaintiffs, saying that, quote, without some overriding legitimate interest, the state cannot use its domestic relations authority to legislate families out of existence. Having failed to establish such an interest in the context of same-sex marriage, the state marriage ban cannot stand. He said that because they did not have a legitimate government interest, it
Mhm.
was in fact unconstitutional. Now, again, it's going to end up going up higher than this. It's going to go all the way to the Supreme Court because this is one of the cases that gets kind of, what's the word, consolidated into what we know as Obergefell v. Hodges. So, speaking of,
Mhm.
then we move into Ohio. So, there were actually two cases that came from Ohio. So, James Obergefell was the first one. And
Mhm.
obviously, he becomes kind of the face of this because his name is the one that's remembered. This is called the Obergefell decision. So,
Mhm.
James Obergefell and John Arthur decided to marry following the U.S. Supreme Court's decision in United States versus Windsor. And
Mhm.
that's a case for another day. But
Mhm.
essentially, they got married in Maryland on July 11th of 2013. However, when they went to return to Ohio, where they
Mhm.
lived, Ohio refused to recognize their marriage. And so they filed a lawsuit, which was originally marked as Obergefell versus Kasich, which
Mhm.
was the sitting governor of Ohio at the time.
Okay.
So they filed suit in the Southern District of Ohio in July of
Mhm.
that same year. So just about a week after their marriage, they filed this lawsuit.
Mhm.
And in it, they alleged that the state discriminated against same sex couples who had lawfully married in another state.
I have a question.
Yes.
How did they find out immediately that they weren't recognized as married in that state? Like, were they trying to file something and they were like, "No," or how did that work, I guess?
Yes. So if you get married in a place that's not where you live, when you go back, like let's say you get like a destination wedding, you still have to file a marriage certificate in your county of residence.
Oh, so he had a
Yes.
marriage certificate in Maryland, and then when he
Yes.
came back to Ohio, they were like, "We don't care, we don't recognize it?"
Yes. So they got married in Maryland. They came home and they were like, here's our marriage certificate. We would like it to be recognized in the state of Ohio. And they're like, no, we're not going to do that. We're not recognizing that because Ohio doesn't recognize same-sex marriage. So one of the big reasons that they brought this lawsuit is because James's husband, John, was
Mhm.
actually suffering from amyotrophic lateral sclerosis or ALS.
Oh, what is
He
that?
was it I don't know all the details, but he was terminally ill. He did not
Oh.
they were not expecting him to live very long.
Mhm.
And he wanted the Ohio registrar John did. He wanted the Ohio registrar to identify Jim as his surviving spouse on his death certificate. So he knew he
Aw.
wasn't gonna live much longer, and he just wanted it to be able to be denoted on his death certificate that this was his husband.
Oh, that's so
And
sad.
I know. So, and the Ohio registrar actually agreed and said this this ban against same-sex married couples is unconstitutional. But the state attorney general doubled down on it and said, "No, we're going to defend the law and we're going to defend the same-sex marriage ban."
Mm, it's so sad.
So I'm not going to get into all of those details. So once again, there's kind of a small victory in Ohio here.
Mhm.
The district judge, Timothy Black, granted a temporary restraining order, which basically meant that the Ohio registrar was restrained from accepting any death certificate unless it recorded the deceased's status as married and his partner as a surviving spouse. So he
Mhm.
basically says, you have to take this and you have
Mhm.
to put on it that he was the surviving spouse. And he said, quote, throughout Ohio's history, Ohio law has been clear. A marriage solemnized outside of Ohio is valid in Ohio if it is valid where solemnized.
Mhm.
The second case in Ohio was kind of similar. So
Mhm.
David Mishner and William Herbert Ives were married in Delaware, and they also had 3 adoptive children.
Okay.
However, about a month later, unfortunately, William Ives died unexpectedly in Ohio. So they were married in Delaware, and then he passed away in Ohio. The issue here is, once again, David wanted to be on the death certificate.
Yeah. Okay.
So
Why? Just curious. I don't know if there's like a reason behind that or what happened, or like a sentimental thing.
so one of the things with being on the death certificate is because it codifies that you were the spouse, it gives you more authority in deciding how to carry out this person's last rites.
Mm-hmm.
So, for instance, in this case, William's remains were being held at a Cincinnati funeral home pending the issuance of a death certificate because
Mm-hmm.
they couldn't cremate him until there was a death certificate. But they couldn't issue a death certificate because his spouse's name couldn't be on the death certificate because Ohio refused to recognize them. So this, again, was before Judge Black. And on September 25th, Judge Black granted a motion by the plaintiffs to dismiss the governor and the state attorney general as defendants and added funeral director Robert Grunn to the lawsuit so that he can obtain clarification of his legal obligations under Ohio law. So he's like, am I allowed to give someone who is legally married in a different state
Mm-hmm.
the remains of a person that they're legally married to if our state doesn't recognize that?
Mm-hmm.
So what am I supposed to do? Am I breaking the law
Yeah.
by releasing the remains, or am I breaking the law by withholding the remains?
Mm-hmm.
So this is where we start to see some of the overlap.
Mm-hmm.
So Robert Grunn was also asking about clarification because he also worked with James Obergefell.
Oh.
So unfortunately, on October 22nd, John Arthur passed away due to complications from his ALS.
Wait, are we hopping back to...
Yes, because these
Okay.
cases are intertwined. Oh, he dies about 2 months after William Ives dies. So in August, William Ives passes away unexpectedly. In October, John Arthur passes away. But again, he was terminally ill. So this is something that they were trying to prepare for
Yeah.
in the issuance of the death certificate. So the state decided to move to dismiss the case as moot because now the plaintiff was deceased. So there was no one to prosecute it.
I thought that wasn't
And
allowed.
what do you mean? Yeah, is it right versus is it moot?
Yeah.
There's like a very small window. Yes. So that's essentially what the judge decides. You're right. The judge says, no, I'm not getting rid of this case. He says, no. On November 1st, he issues a ruling that says, no, we're not dismissing this, denied.
Mm-hmm.
And then on December 23rd of that year, Judge Black ruled that Ohio's refusal to recognize same-sex marriage from other jurisdictions was discriminatory. He wrote, quote, when a state effectively terminates the marriage of a same-sex couple married in another jurisdiction, it intrudes into the private marital, family, and intimate relations specifically protected by the Supreme Court.
Mm-hmm.
So now we move to the next Ohio case.
Oh, so there's 3?
There are kind of 3. So Obergefell and David Meichner's case were combined since they were dealing with the same funeral director.
Oh, I didn't recognize. Okay, I don't think I knew
So
that. I don't think I understood that. Okay,
so they were combined, and then this other case is completely separate. So the second case from Ohio is Henry versus Weismiller. So that was the Ohio Department of Health director.
Okay.
Georgia Nicole York Smith and Pamela York Smith got married in California on October 14th, 2008. They had had a son in 2010, and now they were expecting another child. So that's the first couple. The next couple was Kelly Noe and Kelly McCracken, who were married in Massachusetts. The next couple was Joseph G. Vitale and Robert Thomas, who were married in New York on September 20th, 2011. Now, Joseph and Robert tried to adopt a son through the adoption agency called Adoption Star.
Mm-hmm.
And they were successful and adopted a son on January 17th of 2014.
Mm-hmm.
Then we also have Brittany Henry and Brittany Rogers, who were married in New York on the same day that Joseph and Robert adopted their son.
Mm-hmm.
So the three female couples, so Brittany and Brittany, Kelly and Kelly, and Georgia and
That's so
Pamela,
funny.
I know,
Uh-huh.
they were all living in Ohio.
Mm-hmm. For the listeners, really quick, when you said that Joseph and Robert adopted, so did the other three female couples, like, was one of them pregnant, giving birth to the child?
Yes. So, like I said, the three female couples were all living in Ohio. And then Joseph and Robert were living in New York with their adopted son who was born in Ohio.
Okay.
So on February 10th, 2014, these four legally married couples filed a joint lawsuit together called Henry
Okay.
versus Wise Malone. Also in the United States District Court for the Southern District of Ohio. And they wanted to force the state to list both parents on their children's birth certificates. So rather than death certificates like we saw in the Ohio case, the previous Ohio cases, these were all
Mm-hmm.
focused on birth certificates.
Okay.
But it had the same defendant, Wise Malone, the then director of the Ohio Department of Health.
Mm-hmm.
So those are all of the Ohio cases. We have quite a few. I mean, it's technically two,
Mm-hmm.
but there are several couples, a total of 6 couples coming out of Ohio in those
Mm-hmm.
cases. So we moved down from Ohio to Kentucky. So there were 2 cases that came out of Kentucky. The
Okay.
first encompasses 4 more couples. So the first is Gregory Bork and Michael DeLeon, who were married in Ontario, Canada in 2004. And they had 2 children, a girl and a boy. Next, there was Randall Johnson and Paul Campion, who were married in California on July 3rd, 2008. They had 4 children, twin boys, another boy, and a girl.
Gosh.
Next, there was Jimmy Meade and Luther Barlow, who were married in Iowa on July 30th, 2009. And finally, there was Kimberly Franklin and Tamara Boyd, who were married in Connecticut on July 15th, 2010. All of these couples were residing in Kentucky.
Mm-hmm.
So Bork and DeLeon and their 2 children filed the first lawsuit, which was
Mm-hmm.
titled Bork versus Bashir in the United States District Court for the Western District of Kentucky. And they were challenging Kentucky's ban on same-sex marriage and the recognition of same-sex marriages from other jurisdictions. So again, here the defendant is the then governor of Kentucky, Steve Bashir.
Mm-hmm.
So this is very similar to what we saw in Ohio, where you have people who were married in states where it was legal and are now struggling to get those recognized in the state in which they actually reside.
Mm-hmm.
So as time went on, obviously the other couples were added. It started with Bork and DeLeon and the other 3 couples were eventually added. So on February 12th, 2014, Judge Hayburn II issued the court's decision saying, quote, "In the end, the court concludes that Kentucky's denial of recognition for valid same-sex marriages violates the United States Constitution's guarantee of equal protection under the law, even under the most deferential standard of review. Accordingly, Kentucky statutes and constitutional amendment that mandate this denial are unconstitutional."
It's
So
nice that the
the
judges
second case,
are,
yeah, there were lots of wins on the lower level. Like,
yeah.
things seemed to be going pretty well.
Mm-hmm.
So the second case from Kentucky, Love versus Bashir, involved two couples. So
Mm-hmm.
Maurice Blanchard and Dominique James again held a religious marriage ceremony on June 3rd, 2006. So again, this was a ceremonial thing, but it was not legally
Mm-hmm.
recognized.
Yeah, they
And
did it in Kentucky, which it wasn't allowed, right?
yes, the Kentucky county clerks actually just straight out refused to issue them marriage license. So this one's a little bit different in that they didn't go to a state where it was recognized. They just straight up tried to get married in a state where they knew there was a ban. And then
Mm-hmm.
Timothy Love and Lawrence Yasunza. I'm sure I'm butchering that last name. Yasunza.
Mm-hmm.
I'm doing my best. So they had been living together as a couple for 30 years,
Oh my gosh.
and they were also refused a marriage license. So again, the reason these two were consolidated is because we have very similar facts. They're going and
Yeah.
trying to get a marriage license issued, and they're denied. So on Valentine's Day of 2014, the couple submitted a motion to join Bork versus Bashir, so the case that we just mentioned with the four couples from Kentucky, challenging the state's ban on same-sex marriage.
Mm-hmm. That's
So
sweet because the last name is Love, and then in
I
February.
know,
That's so cute.
I know. And the case was actually restyled as Love versus Bashir. That wraps up Kentucky.
Okay.
On July 1st, 2014, Judge Hayburn, so the
Mm-hmm.
same judge that we saw in the first Kentucky case, issued
Mm-hmm.
his ruling and found, quote, homosexual persons constitute a quasi-suspect class, and found that Kentucky's law banning same-sex marriage, quote, violates the Equal Protection Clause of the 14th Amendment, and they are void and unenforceable.
Mm-hmm.
And I think my personal favorite quote is that when talking about what the state had tried to put forth in explaining why they had come up with these bans, he said, quote, these arguments are not those of serious people.
He said, "Get out
So
of my face."
he was literally like, don't even try that. Let's run
Yeah.
that back. Now we jump a little bit further south to Tennessee. So there
Wait,
was only,
Harleigh,
yes,
are you from Tennessee?
because you're the only 10 I see.
So cute.
So there was only one case that came out of Tennessee. I'm just going to move right past that. There was only
Yeah.
one case that came from Tennessee, and it involved four same-sex couples, Joy Espio and Matthew Mansell, married in California on August 5th, 2008. And then the following year, they adopted two of their foster children.
Hmm.
So Mansell was actually transferred to Tennessee with his job
Mm-hmm.
in 2012. Then the second couple was Kelly Miller and Vanessa DeVias, who were married in New York on July 24th, 2011, and then later moved to Tennessee. The third couple was Army Reservist Sergeant First Class Ichpe Deco. If I said that name wrong, I'm so sorry. I looked it up. I tried. And Thomas Costera, who were married in New York on August 4th, 2011. In May of 2012, after completing a tour of duty in Afghanistan, Sergeant Deco was restationed in Memphis, Tennessee, and that's where the
Mm-hmm.
couple was living. Shout out Memphis. I lived in Memphis for like 10 years. Shout out Memphis. Maybe not in this case because this is not cool, but
Oh.
but shout out Memphis. So on September 3rd of 2013, the Department of Defense began recognizing their marriage, but the state did not. So because Sergeant Deco was a member of the Army, the Department of Defense recognized that he was legally married to his
Mm-hmm.
husband, but the state of Tennessee did not recognize same-sex marriage. The final couple was Valerie Tanco and Sophia Jesty, who were married in New York on September 9th, 2011, and then subsequently moved to Tennessee, where they were working as university professors. And they were actually expecting their first child in 2014.
Oh.
So on October 21st, 2013, wishing to have their out-of-state marriages recognized in Tennessee, all four of the couples filed a lawsuit which was styled as Tanco versus Haslam in the United States District Court for the Middle District of Tennessee.
Okay.
And once again, Haslam was the then governor of Tennessee. On March 14th of 2014, Judge Traeger granted a preliminary injunction requiring the state to recognize the marriages of the three plaintiff couples. So all of the couples were still part of it, except for Kelly Miller and Vanessa DeVias, who did eventually withdraw from the case. They withdrew from the case about 4 days before the preliminary injunction came out. So, in her opinion, Judge Traeger wrote, quote, "At this point, all signs indicate that in the eyes of the United States Constitution, the plaintiffs' marriages will be placed on an equal footing with those of heterosexual couples, and that prescriptions against same-sex marriage will soon become a footnote in the annals of American history."
Aw, that's great.
I know. And everything was beautiful and wonderful until.
Oh, dun, dun, dun. I was
Dun,
wondering
dun,
when
dun,
I was wondering when that was coming.
till the Sixth Circuit hit. 4 of the 6 decisions from the district courts were appealed to the United States Court of Appeals for the Sixth Circuit. Ohio's Director of Health appealed Obergefell versus Weismalow. The governor of Tennessee appealed Tanco versus Haslam. The governor of Michigan appealed DeBoer versus Snyder. And the governor of Kentucky appealed Boert versus Bashir and Love versus Bashir. And eventually,
Like
Ohio.
all at the same time or different times?
No, these were happening very close together. So Obergefell was appealed on January 16th of 2014. Tanco versus Haslam was appealed on March 18th of that same year. 3 days later, on March 21st, is when the governor of Michigan appealed both DeBoer versus Snyder. And then the governor of Kentucky appealed Boert versus Bashir and Love versus Bashir on March 18th and then July 8th, respectively. And then backtracking a little bit, Ohio's Director of Health also appealed Henry versus Himes on May. So this is where they start to get a little bit consolidated. So the Sixth Circuit consolidated Obergefell versus Himes with Henry versus Himes for the purposes of briefing and oral arguments. So this just essentially means that one set of attorneys will write the brief that goes up and will appear for oral arguments before the panel. And then additionally, the Sixth Circuit consolidated Boert versus Bashir and Love versus Bashir for the same reason. On August 6th, a 3-panel judge consisting of Judge Jeffrey Sutton, Judge Deborah L. Cook, and Judge Martha Craig Doherty heard oral arguments in all 4 cases. On August 11th, Richard Hodges, by the appointment of Ohio Governor John Kasich, succeeded Himes as Ohio's health director. And that's how the name got changed to Obergefell v. Hodges. So on November 6, 2014, in a decision that was labeled as DeBoer versus Snyder, the Sixth Circuit ruled 2-1.
When it comes to circuit court, is it always 3 judges that will make a ruling, or is it 1 judge?
It's typically 3, so it's always a panel with the Sixth
Okay.
Circuit, not with the Sixth Circuit,
But not district, right?
any of the Court of Appeals. Yes, with the districts, it's just 1. Anytime you're at an appellate level, though, you're before more than 1 judge.
Okay.
Or at least at the federal level, that's true. Yeah, so there's 3 for Court of Appeals, unless it goes en banc. And sometimes you'll see that in cases they have a little parentheses out to the side that says en banc. That means that all of the judges in that circuit heard this case and made a decision.
Oh.
Yeah. So the Sixth Circuit just heard this in a 3-judge panel, and they ruled 2-1 that Ohio's ban on same-sex marriage did not violate the U.S. Constitution.
You're joking. Oh, another
No.
question. Do we
Yeah.
know if like the judges like each other on the 3 panel, or do they like have beef sometimes? And is it always the same 3 judges, or like
It's not always the same 3. It's kind of randomly selected.
Mhm.
So a lot of it is kind of luck of the draw, because you may get, 3 more conservative judges or 3 more liberal judges or a mix of the 2.
Mhm.
And that's also the reason that appellate courts can't really overrule themselves unless they go en banc. So you
Okay.
can't just call for another 3-person panel. You have to call for it. So, like, if you don't like the
I didn't
answer, you
like the
can't be
three.
like, yeah, can you be like, "Can you draw another 3?" You gotta get everybody or go to the
When you
Supreme
get
Court. Those are your options.
No, the way I would be like, before we get started, I actually don't like that judge. So can we,
Can we not?
yeah.
Ugh.
How do they get the 3 picked out?
I don't know exactly what the process is. All I know is that they're randomly selected.
Okay.
We call it in my district, they call it the wheel. I don't know if it's actually a wheel. Like, I don't know if they spin a wheel to decide what judge gets a certain case,
Yeah.
but it's the wheel. Vaguely the
That's so
wheel.
cool.
But it's completely random. It's supposed to be completely up to chance.
Allegedly.
So, writing for the majority, Judge Sutton dismissed arguments made on behalf of same-sex couples, saying, quote, "Not one of the plaintiff's theories, however, makes the case for constitutionalizing the definition of marriage and for removing the issue from the place it has been since the founding, in the hands of state voters." So
Okay.
Judge Daughtry wrote the dissent, and she
Oh, okay.
said, quote, "Because the correct result is so obvious, one is tempted to speculate that the majority has purposefully taken the contrary position to create the circuit split regarding the legality of same-sex marriage that could prompt a grant of certiorari by the Supreme Court and put an end to the uncertainty of status and the interstate chaos that the current discrepancy in state law threatens." So she basically goes, "Y'all just
Oh,
wanted a
she,
circuit split. Y'all are crazy."
yeah. That's crazy. So that it would be a definite answer.
Yes.
That makes
And
sense, though.
listen, wouldn't you know it, the Supreme Court granted a writ of cert.
Wait, you can't spoil the ending. I don't know if same-sex marriage is legal or not yet. I
You
gotta wait
don't
till the
know.
end.
I'm not sure.
I don't want the ending ruined.
So we're just now getting to where we would normally get in these cases. But I
Uh-huh.
wanted to give some of the background because all of that was kind of the historic context that built up into Obergefell v. Hodges.
It's a lot of
So
moving pieces.
it's a lot of moving pieces.
I
Yeah.
do want to take a moment to say, like, this is a really, really big deal that these couples were willing to put themselves out there in the public eye like this. Like
Yes.
it's really impressive, you know?
That's why I wanted to like kind of give them a spotlight because litigation is stressful, it's expensive.
Yeah.
You are basically branding yourself with a scarlet letter, especially if you're like trying to stand up for something that's controversial
Yeah.
wherever you are. And that's why I wanted like, don't get me wrong, Jim Obergefell is amazing.
Hmm.
But there were so many other couples that were wrapped up into the same litigation. And I
Yeah.
wanted at least part of their story to be told too.
Yeah.
The claimants from each of the 6 district court cases appealed to the Supreme Court of the United States. So the DeBoer petitioners presented the court with the question of whether denying same-sex couples the right to marry violated the 14th Amendment. The Obergefell petitioners asked the court to consider whether Ohio's refusal to recognize marriages from other jurisdictions violated the 14th Amendment's guarantees of due process and equal protection, and whether the state's refusal to recognize the adoption judgment of another state violated the U.S. Constitution's full faith and credit clause. The Tanco petitioners asked the court to consider 3 questions: whether denying same-sex couples the right to marry, including recognition of out-of-state marriages, violated the due process or equal protection clauses of the 14th Amendment, whether refusing to recognize their out-of-state marriages violated same-sex couples' right to interstate travel, and whether Baker v. Nelson from 1972 summarily dismissing same-sex couples' marriage claims remained binding precedent. And then lastly, the Bork petitioners posed to the court 2 questions: whether a state violates the due process or equal protection clauses of the 14th Amendment by prohibiting same-sex couples to marry, and whether it does so by refusing to recognize out-of-state same-sex marriages. All of these cases were then consolidated together. The Supreme Court said, we'll hear all of those questions together.
Mm-hmm.
And it ordered briefing and oral arguments on the following questions. Does the 14th Amendment require a state to license a marriage between two people of the same sex? 2, does the 14th Amendment require a state to recognize a marriage between two people of the same sex when their marriage was lawfully licensed and performed out of state? And then finally, the court also told the parties to each of the 4 cases to address only the questions raised in their particular case. So like Obergefell raises only the second question, the recognition of same-sex marriages from other jurisdictions.
Mm-hmm.
So they're trying to like cull down on the number of questions being asked and get rid of duplicate questions.
Yeah. That'll probably save the attorneys a lot of time too.
Absolutely. So Justice Anthony Kennedy authored the court's opinion. So Justice Kennedy wrote the majority and was joined by Justices Ruth Bader Ginsburg, Stephen Breyer, Sonia Sotomayor, and Elena Kagan. There she is. Stephanie just pulled out her little action figure of Ruth Bader Ginsburg. I have the exact same one that I keep in my office at work.
I love it.
So the majority held that state same-sex marriage bans are a violation of the 14th Amendment's due process and equal protection clauses. So the court actually listed 4 distinct reasons why the fundamental right to marry applies to same-sex couples. So first, quote, the right to personal choice regarding marriage is inherent in the concept of individual autonomy. Second, the right to marry is fundamental because it supports a 2-person union unlike any other in its importance to the committed individuals. Third, the fundamental right to marry safeguards children and families and thus draws meaning from related rights of childbearing, procreation, and education. Fourth, and finally, marriage is a keystone of our social order, and there is no difference between same and opposite-sex couples with respect to this principle. Consequently, preventing same-sex couples from marrying puts them at odds with society, denies them the countless benefits of marriage, and introduces instability into their relationships for no justifiable reason. So the court, specifically citing Griswold versus Connecticut, affirmed that the fundamental rights found in the 14th Amendment's due process clause, quote, extend to certain personal choices central to individual dignity and autonomy, including intimate choices that define personal beliefs and identity. But the identification and protection of these fundamental rights has not been reduced to any formula. And so basically they hearkened back to Loving v. Virginia, which was the case that protected marriage between people of different races, and Turner versus Safley, which also protected the right to marry, I believe, for prisoners. The 2 prisoners in that case wanted to marry, and they were allowed to marry because they said that would be a violation of their rights if they weren't able to marry. And then also Zablocki versus Redhill, which basically held that a prohibition on individuals who had children who were wards of the state. This is a very simplified version, but people who had children who were wards of the state weren't allowed to get married. If your kids had been taken and put into foster care, you weren't allowed to get married. They're just like, it's not something you can do. And the Supreme Court said you can't stop people from getting married.
Yeah.
For that. That's not a legitimate enough reason. And so based on all of those decisions, they were like, it's clear that marriage was meant to be one of these rights found in the 14th Amendment's due process clause. So therefore, it should be protected for same-sex couples in the same way that it was protected for these opposite-sex couples. And then that also ties into the analysis with the equal protection clause. You can't say it's okay here and now it's not okay in the second. So, like I said at the beginning, I want to touch a little bit on the dissent in this case. Scalia wrote a dissenting opinion. Chief Justice John Roberts wrote a dissenting opinion. which was joined in part by Justices Scalia and Thomas. Justice Thomas wrote his own dissenting opinion, specifically talking about substantive due process. And Justice Alito wrote a dissenting opinion. And it's actually Justice Alito's opinion that I want to talk about.
Okay.
So Justice Alito specifically pointed back to the court's precedent in Glucksberg. And I know that I'm citing a lot of cases that we have not yet covered, but essentially what you need to know is that he used Glucksberg to say that the due process clause protects only rights and liberties that are deeply rooted in this nation's history and tradition.
Mm-hmm.
And so Alito claimed that any right to same-sex marriage, by definition, is not protected by the due process clause. And he defended the rationale of the states, basically accepting the premise that same-sex marriage bans serve to promote procreation and the optimal childbearing environment. So one of the
Yeah.
big arguments that was made by the states is that marriage is meant to encourage procreation. It's meant to encourage people to have children. And by nature, same-sex couples cannot naturally conceive children. Justice Kagan actually asked a really great question during oral arguments that I always like to bring up. And that's, she basically asked the state's attorney, so if marriage is only meant to encourage procreation, does that mean it would be constitutional to ban people over the age of 55 from getting married? Which I think is a stellar question because it does call into question that motive.
Yeah.
And it was one of my favorite questions that got asked during the oral arguments. And I re-listened to a good portion of the oral arguments to like get ready for this episode. And I was like, that's such a good mic drop moment. That wouldn't be constitutional. And 55-year-olds can still theoretically have kids. And she basically laughs in his face and is like, you find me a 55-year-old woman that isn't menopausal. Like, she was not playing. Again, going back to Justice Alito's dissent, though, this is where a lot of people, after Dobbs got handed down, started to worry about how secure the holding in Obergefell was. So we will do an episode on Dobbs eventually, but for now, all you need to know is that the right to abortion was overturned in Dobbs. And the rationale that the court used was that that was not a right that was rooted in history and tradition. So that has kind of become the litmus test for whether or not something should be protected by the due process clause. And a lot of these arguments around what you do with your own body, within your own home, your right to privacy.
Yeah, and you have to remember history and traditions. Like, some traditions are really, really bad.
Exactly. And so
a lot of our history was not great.
No, and it's one of the things that I take issue with the history and tradition test. And I will say, and Abraham said he would listen to this case. So Abraham, if you're listening, shout out. This is actually Abraham's argument. So he argues that same-sex marriage should be protected under a history and tradition test because marriage was nothing but a protection of property rights.
Oh, okay, yeah.
Which does go back to the history and tradition of our country and is founded in the basic rights that we laid out. And because marriage was meant to protect, and he harkens this more to the Equal Protection Clause, but because it was meant to protect property, it has to be applied equally. And therefore, same-sex marriage would have to be protected under that ideal. We had a very long discussion about this. It's a very, very interesting take. But essentially, that is where people started to basically have a little bit of doubt as to how sturdy Obergefell was as precedent if we were going to start going back to the history and tradition test, if that was going to be how we decided these types of cases. There's already a roadmap laid out in the dissents of this case that says this is not deeply rooted in history and tradition. A little bit of back and forth of like what was going to happen. So just a couple of years ago in Department of State versus Munoz, the Supreme Court held that a citizen does not have a fundamental liberty interest in her non-citizen spouse being admitted to the country. And this is another one that started to make people a little more nervous about how solid Obergefell was, because, again, they applied the history and tradition test, which was established in Glucksburg. And Justice Sotomayor criticized the majority for using that test because she said it was in clear contradiction to Obergefell, because Obergefell had rejected the history and tradition test when it applies to fundamental rights like marriage and intimacy.
Mm-hmm.
So that started to make people see it as a little bit shakier. In Ermold versus Davis, this happened last year.
Mm-hmm.
You may remember this a little bit. It was on the news for a little bit, but basically we're back in Kentucky. And the clerk, Kim Davis, refused to issue a marriage license to same-sex couples. So she just wouldn't issue it to any same-sex couples.
What? It's literally federal law at this point, isn't it?
Yes. Yes, it is. And so she was found to be personally liable.
Good.
And had to pay $100,000 to
Thank
the couple that
God.
had sued her. And so she appealed to the Sixth Circuit, and the Sixth Circuit said, no, girl, you got to pay it.
That's
So
crazy.
she went to the Supreme Court and specifically asked them to overturn Obergefell based
Oh my
on the
God.
reasoning in Dobbs, specifically pointing to Justice Thomas's concurrence in Dobbs. And the Supreme Court...
Question.
Yes.
Do you think she did that to get to the Supreme Court with this?
Yes.
Okay. So
Yes.
it was to, okay.
Yes,
So this was
100. That's
a
my
lot of
opinion.
people scheming.
That's my opinion.
That's just my opinion. Jinx.
So the Supreme Court declined her petition with no comment. So
they said, get out of here and pay
they said,
$100,000.
bye. So I know that's not a super deep dive into the actual reasoning of the court. But again, essentially, they said Glucksburg history and traditions don't apply to fundamental rights like marriage. Therefore, Glucksburg does not apply to fundamental rights. The history and tradition test from Glucksburg does not apply to fundamental rights. And marriage is a fundamental right. So between the liberty of the Due Process Clause and the equality of the Equal Protection Clause, same-sex marriage bans were determined to be no good.
Yay.
So with that, I do want to talk a little bit about kind of the aftermath of this, because again, this is one of the first ones that I got to see happen.
Mm-hmm.
Again, one of the cool things about this case is that it came out, like I said, June 26th of 2015. And we do not celebrate Pride Month during June because of Obergefell. It is just a happy coincidence. Pride Month is celebrated in June as a nod to the Stonewall riots that kind of served as the first Pride. And so this is just a happy coincidence that this decision was handed down in June. But I remember so vividly the day that this got handed down. And I do want to include this quote from Obergefell himself, who said, "Today's ruling from the Supreme Court affirms what millions across the country already know to be true in our hearts, that our love is equal." And then he expressed his hope that one day the term gay marriage would be a thing of the past and it would only be known as marriage.
Oh.
And there's so many pride parades. I was in Florida at the time. I was on vacation at my graduation trip with my friends, and we turned on the TV like before we went out to the beach. And I just remember like people shouting the steps of the Supreme Court when the decision got handed down. It has to be one of the most beautiful things I've ever seen.
No.
And it just, I don't know. It was such a good day. life felt so good in 2015, but the White House actually lit itself up in pride colors that night after the
Oh,
whole
I
thing
love
came down.
that. I think I
Because
remember that.
because that was back when we had Obama as president, back in the good
Ugh.
days. Back when the most controversial thing a president was doing was wearing a tan suit.
I do think it's really cool, by the way, that because I didn't know this, but President Bill Clinton was the one that recognized it as Pride Month. Did you know that?
No, but that doesn't surprise me. That's so funny.
And we're in Arkansas, the boyhood of Bill Clinton.
The boyhood of Bill Clinton. William Clinton, my boy.
So I thought that was really cool.
Yeah, it was such a great day. And also just fun fact about me, my first tattoo, I got it on that day. That was also not planned. I had an appointment beforehand.
I
But
thought that's why you did it. I was like, well,
no,
that's
I
kind
did
of
not
crazy.
get a tattoo
All right, let's go, guys.
because of
You fresh.
Obergefell. But I have it, like, I have a permanent reminder. And then my second tattoo was also on that same day. It was just a fun little coincidence.
I love that.
But yeah, that is the case of Obergefell versus Hodges. I know that we did not go super into the analysis of it, but I just wanted to give a breakdown of a really important historical case and kind of talk about why it's kind of come back into the conversation in the last few years, even as it doesn't seem explicitly obvious why people are nervous that the protections for same-sex marriage might be in jeopardy.
Mm-hmm.
Why that thought process is there. But yeah.
You did a great job.
Thank you.
I really liked hearing all of that. It's so interesting to like think back. And it's also like honestly weird that we were alive when that wasn't legal. I don't know.
I
My
know.
brain is still kind of like, how is this not just like
It is super strange because my entire adult life, that's just kind of been the reality.
Mhm.
And especially when I started taking courses in college, because shocker, there wasn't a whole lot of queer history taught in my public school in Arkansas. When I started taking
what?
classes in college, because I specifically took classes about LGBTQ plus history, I just think it's so strange because I can't imagine. And don't get me wrong, it's not like everything is peaches and rainbows. But like the fact that it was straight up illegal
Is crazy.
just over a decade ago is insane.
Yeah. Well, I think you did a great job of covering it. I'm really excited that we covered it on their 11th anniversary.
I know. I'm glad that we got to get it out for the anniversary. So happy Pride. Happy Pride Month, everybody.
Yes.
I know that we're winding down on it, but I
happy.
hope everyone's had a great time. I hope you got to go to a parade.
Yes.
Well, that's all we have for today. I do want to give a final shout out to the sponsors of today's episode, Belmonte, a skincare and lifestyle brand centered around the reminder to stay still, grounded, and present. And we once again want to thank Kaplan Bar Prep for partnering with us. If you or someone you know is planning to use Kaplan for bar prep, please be sure to use our code PASSWITHPONZ to save an additional $100 off of your course. Doing this not only allows you to save some money, but it also allows us to continue to give away bar prep courses for each testing cycle. And if you're needing a little extra help with the multiple choice, you can also pop over to UWorld. And we have a code there to save you 10%. That's code Ponzaneli 10, Ponzaneli 10. And once again, as always, you can find our link tree in the show notes. Why am I always trying to say show notes? Why am I always talking about our show's nuts? Be sure to check out our link tree in the show notes. Where you can find links to follow us on TikTok, Instagram. That's also where you can find our Amazon storefront with all of our favorite law school and bar prep essentials. And you can also
my wish list.
You can also buy Stephanie a present if you're feeling super generous. Or
I forgot to tell you something.
Join our Patreon. What?
Yeah, please join our Patreon. Someone bought me the moon lamp.
You're joking.
I'm not.
I gotta start begging for stuff on the internet.
No, because
start begging for stuff on the internet.
Literally, I need to step it up. I'm like, Selena Gomez, was it you?
Selena?
Selena, send me PR. Let me make sure, because I was scrolling through my
Let me make
Amazon
sure it
wish
was
list.
Selena.
No, that it was actually purchased, because I would cry. Yeah, I don't know when it happened, but somebody bought the moon lamp, and I'm so excited. I'm like, yes. I wonder if they listened to that episode where I was crying, screaming, throwing up, begging for the moon lamp. So hopefully they also hear the one with the rug, because I really, really want that.
Oh my God. She stayed
Or
making up a little bit on
anything.
the internet.
Or you can just Venmo me 100 million. Like, either is fine.
100 million is $1 million billion.
Billion. Yeah. um, yeah, so I'm really excited about my moon lamp. Whoever you are, thank you so much. I love you. Keep
Watch it
it
be
coming,
Sean.
queen. Yeah, Sean's like, this poor girl.
This is too much. I can't keep doing this.
We also have an Amazon wish list for a first gen Latina going to law school. So everything that you buy off that list will be given to her before she starts law school. So please check that out. You can buy something super fun and cool for me, and then you can send her something too. Or just me.
Or just, yeah, focus only on Stephanie. Sure.
If you know Selena, tell her to please reply to my TikToks.
Thanks. Thanks in advance for everybody who
Yeah.
knows Selena.
My close and personal friend, Selena Gomez.
My close and personal friend, Selena Gomez. Okay. Well, I think that's it. So thank you guys for listening, and we'll see you next week. Bye.
Bye.